Good morning, everyone. Happy Monday morning to everyone. I see we have a visitor in the room today. I'm sure, is he or she? She. Okay, welcome. What is her name? Toffee. Well, Toffee is beautiful, and we're happy to have her today. Thank you. With that, and just for those who don't know what the oohs and ahs are for, we have a canine friend in the room. That is who Toffee is. So with that, on this happy Monday morning, I will go ahead and ask the secretaries to open the roll.
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Hanson. Here. Hardy. Here. LaRue Hatch. Here. Marzola.
Present.
Moore. Here. Nadeem. Orant Liquor. Here. Roth. Here. Urick. Here. Chair Miller.
Here. And please mark Assembly members Gray and Nadeem present when they arrive. Just a few quick reminders. Please turn off all your electronic devices so that we are not disrupting anything happening during the meeting today. Again, for those viewing, you may view on our Nellis website as well as on our YouTube station for the Nevada Legislature. Just make sure you go in under Assembly and not Senate. Of course, on the agenda, it also talks about, it provides the phone number and meeting ID to call in to testify or make public comment today. We will have public comment at the end of today's meeting. For anyone speaking today, whether presenting or making public comment or testifying, we ask that you say your name and that you spell it so that we have it accurate in the minutes. At this point, for today's agenda, we do have a bill presentation and also our first bill hearing. So first up today, we will start with the presentation. And again, we ask that everyone try to keep their presentations and bill presentations to around 15 to 20 minutes because we always need to have time anticipating there'll be questions from members of the committee. Our first presentation today will be an overview of juvenile justice services within the Division of Child and Family Services. With that, I will give our presenters a few moments to settle in, and please make sure that you introduce yourselves, tell us everyone who's participating in the presentation, and when you are ready, please begin.
Good morning, Madam Chair and members of the committee. For the record, Marla McDade Williams. I serve as the administrator for the Division of Child and Family Services in Nevada's Department of Health and Human Services. With me this morning, I have Sharon Anderson, Deputy Administrator for Juvenile Justice Services. We are going to start with a presentation and overview of juvenile justice services in Nevada. Here is our agenda. We'll give you a general overview, talk about the Juvenile Justice Reform Act, talk about our facilities and our programs, and then some legislative updates. Here is our vision and mission, and I will turn it over to Deputy Anderson.
Good morning, Chair and members of the committee. My name is Sharon Anderson, and I serve as the Deputy Administrator for Juvenile Justice Services for the Division of Child and Family Services, and it's my pleasure to share with you our programs today. So this slide shows that Nevada has always recognized that youth and adults should be treated differently within the justice system. This is why the state's juvenile justice system operates under the Division of Child and Family Services, separate from the adult system. There are several key differences between these two systems. In the adult system, individuals are referred to as defendants. If found guilty by a judge or a jury, they receive a sentence based on minimum and maximum terms established by Nevada law. In contrast, the juvenile justice system refers to individuals as a youth or a child. Instead of a conviction, a judge adjudicates the youth as delinquent. The judge then decides whether the youth remains under the supervision of their local county probation department or is committed to the Division of Child and Family Services. Unlike the adult system, there is no predetermined sentencing for juveniles in Nevada. Instead, the length of time a youth remains in a facility is based on their progress in the program. And on average, youth spend about 6 to 9 months in our state facilities. So this slide explains the roles of counties and the state in Nevada's juvenile justice system. Counties are usually a youth's first point of contact with the system. Their goal is to interview early and at the lowest level possible, and it's a process known as front-end intervention. For the typical teenager, these early interventions are enough to deter them from further trouble. However, some youth continue to engage in delinquent behavior and require additional county-level interventions. If their behaviors persist, a judge may decide to commit them to state custody, which is considered the deep end of the system. So this slide shows the juvenile justice funnel, which represents how youth move through Nevada's juvenile justice system. The majority of youth enter the system at the widest part of the funnel and may or may not go deeper. Counties play a crucial role in diverting youth from further involvement by offering prevention and intervention services. As a result, the funnel narrows, reflecting how many youths are successfully kept in their communities rather than entering state custody. So before I get into what our division does once a youth is committed to DCFS, I want to point out that our work in juvenile justice is guided by federal standards of care outlined by the Juvenile Justice Delinquency Prevention Act. The act is based on a broad notion that youth involved with both the juvenile and adult criminal justice system should be guided by federal standards for care and custody, while also upholding the interests of safety and the prevention of victimization. The act also promotes the use of alternatives to incarceration when possible, aiming to lean in on community supports and services, including mental health services. So we recognize the impact exposure to violence and trauma has on behavior and development, and all staff are trained in trauma-informed care. We have implemented an evidence-based assessment that helps us match evidence-based practices to our youth based on their needs. We also focus on family engagement, which I will talk about later in this presentation. When a youth is committed to DCFS, we take into consideration that the majority of them experience some type of trauma in their lives, whether it is physical, emotional, or sexual abuse. They're coming from tough situations, and many were not set up for success. Our admissions team reviews the documentation for each newly committed youth and makes a placement determination based on each youth's history and needs. Most youth are appropriate for placement in one of our state facilities. They are the youth who have not been successful with county-level interventions, their delinquent behavior has escalated, or the nature of their delinquent acts causes the judge to bypass county interventions altogether. Those youth are admitted to either the Caliente Youth Center or the Nevada Youth Training Center, which are both staff-secure facilities, or they are admitted to the Summit View Youth Center, which is our highest-level secured facility. Some youth, however, are committed to our care who are not appropriate for a juvenile justice facility. These are the youth who need significant mental health services. This is a youth who has been actively suicidal within the last month or so, has multiple co-occurring diagnoses, or has a profound intellectual or developmental disability. These youth are typically diverted to a mental health facility in our state or to specialized treatment in other states. We also have unique challenges with youth who are in the child welfare system and in the custody of a child welfare agency. These youth are also committed to the custody of DCFS. Finding an appropriate placement once they have earned their release can be a challenge. These youth do not have a family home to return to, and foster care placements are scarce. And unfortunately, through no fault of their own, some remain in our facilities longer than necessary while a placement is being sought out. So when youth are committed to DCFS, our role is not to punish them, but to provide them the support they need to succeed. Each youth receives an individualized program tailored to their specific needs. Remember, Nevada does not have determinate sentencing for juveniles, so the length of stay in our facilities depends on the youth's progress within the program, which typically lasts between 6 to 9 months. We don't want youth in our facilities longer because we know research says that keeping them longer is not helpful to them. In fact, it impacts their mental health and does not reduce delinquent behavior. Each facility has an on-site school that allows youth to earn credits towards their high school diploma, or they can earn a high school equivalent certificate. We have limited career and technical educational opportunities because we have struggled with obtaining and maintaining the teachers to teach those classes. But each facility offers mental health services. So this slide shows the variety of mental health and substance use services that are at each of the facilities. Our mental health team works hard to address the mental health needs of the youth in our care. We continue to see high levels of mental health needs, including youth with self-harm thoughts and actions. We serve pregnant youth through their third trimester. These youth receive prenatal care and are paroled and return to their community prior to their third trimester due to the prenatal care needs being more extensive. Our facility staff are dedicated and compassionate individuals who are committed to the well-being and success of youth in our care. They work to keep youth connected to their families and support systems while they're in our facilities. Because of their attentiveness and commitment, staff have been able to recognize and intervene in crisis situations, even saving lives when youth struggle with thoughts of self-harm. They actively engage with youth, encouraging them to participate in programs that help them turn their lives around. Despite the challenges, our staff go above and beyond, often working overtime to ensure that every shift is covered and that youth receive the supervision and support they need. So we know that youth do better in the juvenile justice system when they maintain a strong relationship with their family and when their family can be involved in their treatment planning process. DCFS has a statewide plan outlining the responsibility of our facilities and the Youth Parole Bureau to engage families in their child's treatment throughout their commitment to DCFS. This includes engaging them in the development of their child's case plan and inviting them to monthly child and family team meetings where the family can actively participate and provide feedback on the plan and make suggestions to improve the plan. Since COVID, we have had more family engagement with youth in our care, as this is when we began using video conferencing for visits and for meetings. We also have a family travel program that provides financial assistance for travel if that is a barrier to them visiting their child while they are residing in one of our facilities. So when youth complete their programming at one of our facilities, they achieve parole status and they return to their communities and are supervised by our Youth Parole Bureau. The goal of youth parole is to supervise the youth's transition back into the community and assist them with goals related to their independence and to reduce their risk to reoffend. Youth on parole receive individualized plans and supervision based on their needs, which might include a global positioning system device, which is also known as a GPS, substance use treatment, psychosocial rehabilitation, basic skills training, or other services to assist with their successful transition back into the community. These services are designed to help the youth commit to sobriety, graduate high school or earn their high school equivalency, and gain employment. Youth parole counselors also have the duty and responsibility to hold youth accountable should the youth continue to engage in delinquent activity. The next two slides highlight the programs office, which is responsible for policies, planning, quality assurance of the system, and management of federal grants. The programs office also works with the facilities to ensure compliance with the Juvenile Justice Delinquency Prevention Act, which I described earlier. They gather and evaluate data for state and county facilities and use the data to make informed decisions, fulfill various reporting requirements, and to monitor performance-based standards. The program office also monitors compliance with the Prison Rape Elimination Act, also known as PREA, which is a federal law supporting the prevention, detection, and response to sexual abuse and sexual harassment with facilities. So this slide is, the next slide is our legislative bill update from the 2023 session. So Senate Bill 8 passed and updated NRS 289.470, which added a DCFS criminal investigator to the list of Category 2 officers. This addition allowed the division to add a full-time criminal investigator to our roster, and the position's primary role is investigating allegations related to the Prison Rape Elimination Act in all three of our state facilities. So we have successfully onboarded this position, and we did that in June of 2024. So the other bills listed have successfully been incorporated into mandatory trainings, policies, and procedures. So the next slide is our legislative recommendation for the 2025 session. Assembly Bill 7 modifies the membership requirements of the Juvenile Justice Oversight Commission. Current statutory requirements for membership are incompatible with the federal requirements for membership, and the state is at risk of losing federal funds. The Title II formula grant supports one full-time state employee and provides funds to local departments of juvenile services for youth services, and we need to align our statute with federal language to ensure eligibility. So that concludes my presentation. I'm here to answer any questions that you may have.
Thank you so much. We do have a few questions. We will start with Assemblymember Gonzalez.
Good morning. Thank you, Chair, and thank you so much for being here. On this slide, talking about your facilities, it listed secure, staff secured versus secured, and I was just wondering if you could talk about what the difference between those two are. Thank you.
Thank you for the question. Sharon Anderson, for the record, to you, Chair, through you to Assemblymember Gonzalez.
Please go direct.
Thank you. So the difference between staff secure and facility secure is what you would typically find at the prisons, right? The doors closed shut and you're not allowed to leave or come in or go out without being let out through the doors, right? So it's secured. It's an actual physically secured facility. Staff secure is when staff are the ones who deter any for the youth leaving without permission or folks coming on site without permission. So there are no locked doors at those facilities. Mm-hmm.
Our next question is from Assemblymember Gray.
Thank you, Madam Chair, and good morning. Good morning. Thank you guys for the presentation. One question I've been trying to get to the bottom of, and so been told we don't do it, but we've got, youth in, that are, for lack of better words, in our custody. Are we collecting child support from the parents or assessing them any child support since the state is meeting all their needs on a daily basis?
Thank you for your question, Assemblymember Gray. Sharon Anderson, for the record, we do not collect child support from families for the youth in our custody.
What was that, Assemblymember?
May I have a follow-on, ma'am?
Please.
Thank you. Simple question, why not? And what can we do to enact that? I mean, I know a lot of parents don't have the money, but when parents get divorced, there's still child support assessed.
Thank you again for the question, Assemblymember Gray. Sharon Anderson, for the record. There was a time when child support was in orders. I don't recall, it was a few sessions back where that was discouraged. And so I know that that is something that is not ordered by the courts. I don't know if you had anything else. Okay, that's the answer.
Thank you. Our next question is from Assemblymember Roth.
Thank you, and thank you for the presentation. Thank you, Chair. Can you shine some light on the process for youth who are justice involved, who are going through the competency procedures, and what happens when they're found incompetent over and unable to regain competency? Are those individuals, those kids, within your custody and control?
Thank you, Madam Chair. For the record, Marla McDade Williams. So the issue of competency is something that's relatively new to us. I am only aware of one current case where it has worked itself through the courts and the youth was ordered to us for competency, and we do not have any facilities that are really set up for that like the adult system does. So we currently have been unable to take that youth. We do have some statutory obligation, but we don't have any resource following that statutory obligation to actually manage those youth.
Thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you so much, Chair, and thank you for your presentation. My question is about parole. As a teacher, I've had several students that were on parole. I teach high school, and every single one of them has been focused on their grades and getting their life straight, and I think that's a testament to your work. But my question is, what coordination happens between your agency and teachers or schools when students are coming back to us?
That is a great question. Thank you for that question, Assemblymember LaRue Hatch, Sharon Anderson, for the record. So we have a liaison with Clark County School District who assists the youth with their transition back to their assigned school district. And so they attempt to do a warm handoff. They meet with the families and let the families know where the youth are to report. They will also, when the support is needed, will meet the families with the student at the location to ensure the youth are enrolled in school once they earn parole.
Thank you for that. My follow-up is there any information that is shared with the teachers or the schools so that they know the situation and they know certain things they should avoid or they should be doing to help support?
Another great question, Assemblymember LaRue Hatch, Sharon Anderson, for the record. The youth who are involved with the juvenile justice system it's a confidential matter. So there is no sharing of any juvenile justice issues. There is an attempt to do a smooth transition so that the youth is not identified, by any connection with us as someone who might be a challenge for that school.
Thank you. Our next question is from Assemblymember Hanson.
Good morning, and thank you, Chair. Thank you for being here and for the work you do. I have two, but I'm going to start with one and then see if I get some could follow up. Can you refresh some of our memories and then maybe help the new members understand what happens with youth who commit certain crimes where they move into the adult population? If we can understand that process a little bit about certifying, if a youth is a minor and has committed a murder, if I'm not mistaken, there's certain crimes that they can't stay in the juvenile system. If you could maybe cover that so we could have a good understanding of how that works.
Thank you for the question, Assemblymember Hanson, Sharon Anderson, for the record. The question would really be better posed to an attorney, but I know that there are certain levels of felonies that would be considered a direct file, meaning there is no consideration of the juvenile court. It's an automatic filing in the adult system. There are some discretionary filings, and depending on if that youth is on probation or parole or if it's a brand new case, then there is a requirement for the probation or the parole department to compose a report that speaks to, I believe it's the 7 minors case that identifies, whether or not it'll share the youth's background. And I know that the recommendation for being served, whether or not the youth can be served in the juvenile system or the adult system, is not a decision that is put forth from either of those departments. That is something that is argued between the attorneys, and then I believe the judge is the one who makes the final decision.
Thank you for clarifying that, and you did a great job. Chair, if we had time, could I just follow up with one more?
Is it a follow-up for clarification to the first response or a separate question?
It's actually separate about solitary
Okay,
confinement.
then I'll come back around to you.
Okay, thanks.
Thanks. Our next question is from Assemblymember Gonzalez.
Thank you so much, Chair, for another question. I was wondering if you could talk about some of the challenges that you were talking about when you were presenting about teacher retention and kind of what's going on with teachers not wanting to teach or the difficulty of having teachers. Thank you.
Thank you for the question, Assemblymember Gonzalez. Sharon Anderson, for the record. Our Caliente Youth Center is, and Nevada Youth Training Center, and some of you all have, the facilities to be able to facilitate additional career and technical trainings. We have just been challenged with hiring folks who have the skill set to be able to teach those classes. We do have some, but there was a time when we had a more robust career and technical training within our facilities, and that just, we had a mass exodus of teachers. When was that? I don't want to say the year and be wrong, but that has it just took a hit, and we've not been able to get back up to that level of ability to teach those classes. So a lot of them retired, right? And it's just been really hard to get them on board.
Madam Chair, if I may supplement, Marla McDade Williams. So NYTC is its own high school, it's Independence High School, and so we hire teachers there under the state system. So we're in competition with Elko County School District for any teachers that would want to come in there. Caliana Youth Center also has its own school,
Lincoln County.
and Lincoln County manages that school. And then Summit View is a contract with Clark County School District. So we're dependent on Clark County teachers to be able to staff the facility. Some of it is just cost and competition, I think primarily.
Thank you. The next question will be from Assemblymember Hanson.
Thank you, Chair. Just wanted to touch a little bit on, I don't think we call it solitary confinement in the juvenile system. I think it's called separation or isolation. I think there's a different term. So SB 307 last session put some guardrails in for solitary confinement in the adult population. So there were some reforms there, not to maybe exceed 15 days. On the juvenile side, having some concerns about the use of solitary confinement, for lack of the right term. Can you explain to us how that's used, how long our youth, when you do utilize it, how long that might be for them?
Thank you for the question, Assemblymember Hanson. Sharon Anderson for the record. So we don't use solitary confinement. Youth they may have room confinement time for safety reasons, but that time is really controlled by the youth and their readiness to re-enter programming. And so they have a meeting with the lead worker to have a conversation to commit to safety, and that time can be as little as a minute to as long as it takes for that youth to commit to safety. So we don't do days in confinement. We don't do solitary confinement at all. So.
Chair, can I just follow up with that?
Yes, please.
Oh, well, I'm glad to hear that. That wasn't my understanding, so maybe we can have a discussion afterwards. So, on the record, no, in our state facilities is what you're talking about, or any facility for use housing juveniles. We don't use an isolation room longer than maybe a few hours, not days.
Sharon Anderson for the record. Thank you for the question, Assemblymember Hanson. Let me see. So room confinement is considered, you know what, if I can do this, I apologize. I'd rather respond offline so that I give you fully accurate information. I do have an understanding of it, but I don't want to misspeak. It's not that we don't use room confinement. It definitely is controlled by the youth and their ability to commit to safety.
You know what, we'll go ahead because we have legal here. So I'm just going to ask Ms. O'Krent to respond to that because it is in statute. Thank you.
Thank you.
Hi, Carly O'Krent for the record. Assemblymember, you'll find the existing laws relating to corrective room restriction, which is what this is referred to, in NRS 62B215, which prescribes the conditions and limitations for corrective room restriction.
And Ms. Okrent, do we have any other details about what specified the parameters around its usage?
Sure. So as the presenter mentioned, there are a number of different limitations on that. So Assemblymember Hanson referred to a bill from last session that made changes to this as well. There are requirements relating to exercise. There are requirements relating to family visitation and food. In general, those requirements are intended to ensure that a person who is a child who is subjected to corrective room restriction is receiving the same food as folks in the general population, or whatever the juvenile equivalent to general population would be. And it does set a maximum number of days during which a child can be subject to corrective room restriction. Again, that's 62B 215.
Thank you for that, Ms. Okrent. Not seeing any additional questions, I thank you for the presentation and for your responses to the questions from members, and I will go ahead and close this agenda item for the presentation. The next item on our agenda is a bill presentation. This will be our first bill presentation of the session, and it is on Assembly Bill 7, which is a measure revising provisions relating to the Juvenile Justice Oversight Commission. We have the same presenters that are presenting the bill, so if you need a few moments to change over, switch over, whatever you need, but whenever you are ready, please reintroduce yourself, as this is a new agenda item, and proceed.
Good morning, Chair and members of the committee. My name is Sharon Anderson, and I serve as the Deputy Administrator of the Division of Child and Family Services, Juvenile Justice Services, and it's my pleasure to share our Assembly Bill 7 testimony with you here today. So Assembly Bill 7 modifies the membership of the Juvenile Justice Oversight Commission to meet federal requirements for an advisory body. The current membership of the Juvenile Justice Oversight Commission, as outlined in NRS 62B.600, does not meet federal requirements, and the state is at risk of losing roughly $600,000 in federal funds or the entire Title II formula grant allotment annually. NRS 62B.600 was added in 2017 during the 79th session. Prior to this legislation, there was a Juvenile Justice Commission with no membership requirements outlined in NRS. The Juvenile Justice Commission acted as what is known as the State Advisory Group in accordance with the Juvenile Justice Delinquency Prevention Act. When it was adopted, NRS 62B.600 disbanded the Juvenile Justice Commission that was in existence at the time and moved all duties to the Juvenile Justice Oversight Commission. However, that action immediately created a situation where membership of the Juvenile Justice Oversight Commission did not meet federal requirements to act as the state advisory group. So amending NRS 62B.600 would, one, identify and clarify specific membership needs that are required by the Juvenile Justice Delinquency Prevention Act, ensure an appropriate balance of government and non-government employees, and increase membership terms from 2 years to 4 years. This decreases the burden on the governor's requirement to appoint or reappoint members every 4 years as opposed to every 2 years. This also decreases the burden on members' requirement to reapply every 4 years as opposed to every 2 years. That concludes my testimony, and I'm happy to answer any questions you may have.
Wow, a presentation as brief as the bill. Okay, so with that, we will go ahead and begin with questions. The first question comes from Vice Chair Marzola.
Thank you, Chair, and thank you for being here today. I have a couple of questions, if that's okay, Chair.
Yes, Vice Chair, please proceed.
Thank you. And I could maybe be misunderstanding, so I need you to walk me through a couple of things. When was the last time that the commission met?
Sharon Anderson, for the record, thank you for the question, Vice Chair Marzola. The last time the commission met was, I want to say it was December or November of this past year.
Thank you. My next question, in section 2, it states that on October 1st, 2025, the representations of the incumbents will expire. Am I reading that right?
Sharon Anderson, for the record, yes.
Okay. And then on section 2, part 2, it states that the governor will appoint as soon as practical or after October 1st, 2025, new members to the commission. So my question is, I guess if you can define what practical means, and 2, if for some reason the governor does not appoint anyone until after October 1st, 2025, does that mean there will be no members to the commission at that point?
That is a very good question, Vice Chair Marzola. Sharon Anderson, for the record. The intention of having the commission begin October 1, 2025 is to give the current commission an opportunity to have a sunset while simultaneously recruiting to be able to have the sunrise of the newly designed, for lack of a better word, commission to begin its work on October the 1st, 2025, so that there will not be a lapse.
So as soon as the current incumbents expire, then we will absolutely have new members simultaneously, like you stated, on October 1st, 2025. I guess it's the, as soon as practical on or after October 1st, that makes me a little nervous.
Vice Chair, Ms. O'Krent can respond to how we can address the gap. So we'll give a moment to respond. Yes.
Thank you.
Carly O'Krent, for the record. You'll find language to this effect throughout NRS in terms of as soon as reasonably practicable, but if the committee is concerned that absent some kind of authorizing language that would allow this work to begin before October 1st, then we can, the committee can vote to amend the bill to include authorization prior to that. So it would make that part effective passage upon passage and approval, and then those folks would take office yet again. The new folks would be appointed on October 1st, if that makes sense.
It does, and it makes me a lot more comfortable, and maybe we can take this offline, just in case the governor's office doesn't appoint the new members in the, by October 1st, 2025, at least we still have some sort of coverage, so we can make sure that nothing is delayed. Thank you. Thank you, Chair.
Madam Chair, Marla McDade Williams, if I could serve as the administrator for the Division of Child and Family Services, if I could point to section 1.2, it says that each appointed member serves a term, and then it says any vacancies occurring in the membership must be filled in the same manner as the original appointment, not later than 30 days after the vacancy occurs. So I think there would be some expectation that the governor fills any vacancies within 30 days of that October 1st date if there was a vacancy.
Thank you for that. Our next question is from Assemblymember Dahlia.
Thank you, Chair, and thank you for your presentation. I have a quick point of clarification. So it appears that the membership change kicks out to the federal statute. So it's clear that that part's about the federal dollars, but the change from 2 years to 4 years, is that more about administrative convenience than the federal concern? Thank you.
Thank you for the question, Assemblymember Dahlia. Sharon Anderson, for the record, yes, it's more about convenience than it is about the federal requirements. Thank you.
Thank you. Our next question is from Assemblymember Hardy.
Thank you, Chair. So I was just curious, you mentioned that the need for this change was because it didn't meet the federal requirements, and thus the funding. What's been happening since 2017? Have we been getting those dollars, or what has happened with that?
Thank you for the question, Assemblymember Hardy. Sharon Anderson, for the record. We have experienced periods of frozen funds, and our programs office has worked really hard to get the requirements to federal standards. and we've been able to be successful at times, but we have experienced times of frozen funds.
Thank you for that. Our next question is from Assemblymember Roth.
Thank you, and thank you so much for the presentation. Obviously, I think it's incredibly important that we ensure that the state is receiving the federal funding necessary in meeting those requirements. I do have some concerns that with the change in the makeup of the commission, that we're losing some really valuable voices, including both district attorneys and public defenders who work directly with this population. When looking at the federal statute, and maybe this is a question for LCB that we can take offline, but, is this a baseline that we can say in addition to, we include some other voices on this commission to ensure that we're not losing those valuable voices that are working directly with the population? Because that is a concern of mine.
Madam Chair, if I may respond, Marla McDade Williams. Before this change came forward, we vetted it with the current members of the Juvenile Justice Oversight Commission. We didn't have anybody express any concern that there would be any underrepresentation of respective professions on the group. I think what we would like to do is maybe take it back to them and have some of that level of discussion. I believe right now, we believe that the way it's laid out, that there would continue to be adequate representation on the group. And so this is we haven't had any of that, that concern voiced previous to this, but we would take it back and see if there's any concern from the current members about that.
Thank you. Our next question is from Assemblymember Moore.
Thank you, Chair, and thank you for the bill presentation. Similar to what my colleague said, I am wondering what the reasoning was behind removing the requirements for the current makeup of the board and just making why that change.
Thank you, Assemblymember Moore, for the question. Sharon Anderson, for the record. The reasoning for the change is so that we can be in alignment with what the federal law requires for a state advisory group. You're welcome.
Thank you for that. And just for clarification for the committee, would you mind submitting that requirements to the committee?
Sharon Anderson, for the record. Yes, Chair, I will submit that. Thank you.
Thank you so much. With that, I don't see any additional member questions. So I will go ahead and open it up for testimony. And just again, this is our first time testifying in a bill hearing committee. Want to remind everyone that when someone is testifying in support of the bill, that means you are in 100% support of the bill as is. If you as soon as we start saying things like but or if, anything that would suggest a change or an amendment, then you are not in full support of the bill, and that would be appropriate for an opposition. Again, testifying in neutral is not as common. It's used for when someone wants to just state actual facts about a bill. So we will give everyone an opportunity. Again, the format is we will start here in Carson City. We will then move to Las Vegas, and then we will open the phones. Again, we ask anyone testifying that, again, you limit your comments to 2 minutes. And of course, you are more than welcome to offer more in writing later. And so we will start with anyone that would like to come forward in support of Assembly Bill Assembly Bill 7. So if there is anyone here in support of Assembly Bill 7, please come forward. Not seeing anyone here in Carson City, is there anyone in Las Vegas in support of Assembly Bill 7? Not seeing anyone. Broadcasting, will you open the lines, please?
If you would like to testify in support of Assembly Bill 7, please press star 9 or raise hand in your Zoom window now to take your place in the queue.
I will also take this moment.
Again, if you would like to testify in support of Assembly Bill 7, please press star 9 now. Chair, the public line is open and working, but there are no callers choosing to testify in support at this time.
Okay, thank you. I'll take this moment to verbally announce the numbers for today if there are Nevadans that are looking for the phone numbers on the agenda. Again, the number today to call in is 1-888-475-4499, and the meeting ID, when prompted, is 862-8864-6677. And again, that's listed on the agenda that's posted on Nellis. Not seeing anyone in support, I will open it up for anyone in opposition of Assembly Bill 7. And again, please remember to state your name and spell it so we have it for the record.
Good morning, Chair. John Piro from the Clark County Public Defender's Office, JOHNPIRO. First bill hearing, first opposition of the session. We had offered a conceptual amendment to the sponsors, but as we understand it, they're not necessarily receptive at this time. What we would say is we have a few concerns removing the members of the district attorneys and the members of the public defenders. Most of the statutes that list out committees throughout the state are formed the way that it is proposed to be eliminated here. And I don't know a person in this room that thinks that the federal government operates more efficiently than the Nevada state government. Keeping the public defenders and district attorneys part of this committee will not violate the federal law, will still make us eligible for grants, and will still keep us part of the conversation. One of the things that I find problematic when working with committees throughout the state and in Clark County is that some of us are in silos, and we've been working very hard to break down those silos. If we were to be removed from these committees, this would be a siloed off process. We'd ask that this legislative body keep us part of this conversation in statute.
Is there anyone else here in Carson City? And again, we have 3 chairs here, so you may fill the chairs and rotate out while we're in testimony, but please proceed.
Thank you, Madam Chair. Allie Bannister, for the record, ALIBANISTER. I'm the Chief of Juvenile Services in Carson City. I'm also a current member of the JJOC and the Vice President of the Nevada Association of Juvenile Justice. The only concern I think that I have regarding this bill is what Assemblymember Roth was stating in regards to people with the historical perspective that have been on the JJOC for a really long time. There's some really great and valuable members that are currently serving on the JJOC. They've been there for years. They're members of the juvenile justice, whether they be chiefs or administrators. They have valuable insight and perspective. So I think that my concern with all of the members being eliminated in October is that would eliminate all of the historical perspective and knowledge of the current JJOC.
Thank you for that. Not seeing anyone else here in Carson City. Is there anyone, I should ask, is there anyone physically in Las Vegas right now besides staff? Oh, okay, I don't believe so. I do see staff though. All right, with that, broadcasting, will you please open the lines?
If you would like to testify in opposition to Assembly Bill 7, please press star 9 or raise hand in your Zoom window now to take your place in the queue. Again, if you'd like to testify in opposition to Assembly Bill 7, please press star 9 or raise hand in your Zoom window now. Chair, the public line is open and working, but there are no callers choosing to testify in opposition at this time.
Thank you. With that, I will open it up for testimony in neutral. If there's anyone here in Carson City that would like to testify in neutral. Not seeing anyone, and also knowing there's no one in Las Vegas, Broadcasting, will you open the lines for anyone wishing to testify in neutral?
If you would like to testify in neutral for Assembly Bill 7, please press star 9 or raise hand in your Zoom window now to take your place in the queue. Again, if you would like to testify in neutral for AB 7, please press star 9 or raise hand in your Zoom window now. Chair, the public line is open and working, but there are no callers choosing to testify in neutral at this time.
Thank you for that. I would ask the bill presenters, do you have any final brief remarks to make?
Thank you, Madam Chair. For the record, Marla McDade Williams. We're certainly not opposed to having discussions about ways to make the bill better. It's unfortunate we did not get a conceptual amendment. The bill has been out, as you know, we're a state agency. It's been in pre-file for a number of months now, and before the hearing is when we heard about a conceptual amendment on it. So as indicated, we will go back and discuss it with the commission and determine a path forward. Thank you.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 7. Next order of business is public comment. So now, just to remind folks, because it's a transition when it comes from public comment when we are having bill hearings, that public comment should be to anything under the purview of this committee, but it is not to make comment on the bills that were heard. So during the bill hearing is when we have the opportunity to make testimony, but public comment will not be about the actual bills that had been heard. So with that, just a reminder that our phone number again is 1-888-475-4499. And the meeting ID is 862-8864-6677. Again, asking individuals to state their name and spell it for the record. With that, I'll invite anyone here in Carson City that would like to approach and make public comment. Not seeing anyone here in Carson. Knowing there's no one there in Las Vegas, Broadcasting, will you please open the lines?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now.
Greetings, Chair and committee. My name is Jagada Chambers, Jagada, last name Chambers, Chambers. I'm a Clark County School District father. I just wanted to touch briefly on the certification process. I know that the Division of Child and Family Services does have an avenue of interest in that. I know that number has grown tremendously, so I definitely wish they could have responded to those numbers and where they are with those scenarios of kids being thrust out of the juvenile justice system into the adult court system. Another thing that I wish could have been mentioned or I may have missed is about the discipline that goes on in those spaces that were mentioned today. I know that Spring Mountain Youth Camp is out of the county, but definitely goes through the fingertips of the Child and Family Services. I don't know if pepper spray is still common or what they call gas, but definitely would be curious about what that disciplinary looks like. And then finally, I know on Nellis that I didn't see the slide deck attached, or like the chair had mentioned, the requirements from the federals. Hopefully those could be added in to the Nellis slide, the Nellis attachment spots. Okay, I'll say that much. Enjoy the rest of your day, Chair.
If you have recently joined and would like to provide public comment, please press star 9 now. Caller with the last three digits, 556, please press star 6 to unmute your phone. You may begin.
Anne Marie Grant for the record, ANNEMARIEGRANT. I am the sister of Thomas Purdy, who was murdered by Reno police in 2015 during a mental health crisis. He was hogtied and asphyxiated to death for asking for help. No officers were held accountable, and I see that there's hardly any reform bills this year, so I guess that was just a fad of 2021, but I'd like to remind you that watered-down bills are not designed to prosecute the police, but rather to restore public confidence in the police. They are used to diffuse demand for prosecuting police brutality and minimize punishment for guilty cops. What families really want is true change so no other families have to know the pain my family knows, and for our loved ones killed to be held accountable, as anyone not wearing a badge would be. DAs prosecute police who use excessive force. That never happens in Washoe County, Nevada. My brother's case and the two other men, because he was one of three men asphyxiated at the Washoe County Jail within a one-year period, the district attorney, Christopher Hicks, who is still in office and still perpetuating corruption, did not even review any of the three asphyxiation deaths. People are still dying in your state. They are being murdered by law enforcement. And I hope you haven't forgot about that, because my family will never forget what happened to my brother, Nico Smith, and Justin Thompson at the Washoe County Jail. Thank you.
Chair, the public line is open and working. There are no other callers to provide public comment at this time.
Okay, thank you for that. I will go ahead and close public comment. And just to give you sort of the lay of the land for the rest of the week will be a combination of presentations and bills. And this will be our last week of presentations. With that, we have concluded our business for today, and I will adjourn this meeting and see you all back at 8 a.m. tomorrow morning. This meeting is adjourned.